Welcome to the Legal Lounge here on CRN Digital Talk Radio, crntalk.com, streaming live coast to coast and around the world on crntalk.com, also on facebook.com/crntalk, on CRN's X account, also on Rumble, anywhere you can find high-quality content, you can find us. I'm joined, as always, by the one and the only, an active attorney, U.S. Army veteran, Juris Doctorate in law, undergraduate degree in physics, and author of a book that has proven to be a guideline for the Supreme Court now and in the future. That book, America, An Illusion of Freedom, is available on Amazon.com, Barnes & Noble, and on iTunes. Check them out on AM870 The Answer. Ladies and gentlemen, it's Mr. Richard Nixon and the show that gives you the news you get nowhere else. Sorry, Richard.
Just fine. I may have a few negative things to say against my boy Trump.
Oh, watch out.
Even though I'm a pro Trump guy all the way, I got something I got to say.
Okay. We're going to hold our fire on that just briefly because we have discussed some of the news of the week. First thing, speaking of President Trump, he put pen to paper, got another executive order out there, Richard. This one has to do with prosecuting burning of the American flag. Just real briefly, by the authority vested in me as President of the Constitution of the laws of the United States, it is hereby ordered. Our great American flag is the most sacred and cherished symbol of the United States of America and of American freedom, identity, and strength. Over nearly 2.5 centuries, many thousands of American patriots have fought, bled, and died to keep the stars and stripes waving proudly. The American flag is a special symbol in our national life that should unite and represent all Americans of every background and walk of life. Desecrating it is uniquely offensive and provocative. It is a statement of contempt, hostility, and violence against our nation, the clearest possible expression of opposition to the political union that preserves our rights, liberties, and security. Burning this representation of America may incite violence and riots. American flag bursting is used by groups of foreign nationals as a calculated act to intimidate and threaten violence against Americans because of their nationality and place of birth. Here's the important part, folks. Notwithstanding the Supreme Court's ruling on the First Amendment protections, the court has never held that the American flag desecration conducted in a manner that is, and this is the second important part, likely to incite eminent lawless action, or that is an action amounting to fighting words, is constitutionally protected. Richard, your thoughts?
Well, yes, my thoughts are, first of all, we know from the Constitution, Article 2, Section 3, that he, that is to say, the president, shall take care that the laws be faithfully executed. Now, his executive order has to be based upon some law. Did he point to any law, any case, or anything that suggests that he has the authority to issue punishment, if you will, for the consecration or desecration of the American flag? I'm not sure he does. But anyway, putting that aside, if we go back to Texas versus Johnson, a 1989 case, Johnson, he was the defendant. He was a member of the Revolutionary Communist Youth Brigade. He participated in a political demonstration during the 1984 Republican National Convention in Dallas. They and others marched through the streets shouting chants, destroying property, breaking windows, throwing beer cans and various other items. Anyway, at one point, another demonstrator handed Johnson an American flag.
Hold your fire right there, Richard. Right against this hard break. We're going to continue this discussion right after the break. Stay with us, folks. You're listening to the Legal Lounge, Richard Nixon Live. Make sure to follow Richard on Parler at PRES37TH. You can email him at PRES37TH at AOL.com. More on this right after the break. Stay with us.
Hi, everyone. Super Bowl champ Vernon Davis here from Legal Help Center. If you've been injured in an accident and think you deserve compensation, listen up, because we have legal professionals standing by right now to answer your questions for free. You can find out if you have a case and how much it's potentially worth. The call is free, the consultation is free, and you can speak with a live agent right now. So if you or someone you know were injured in an accident of any kind, call now to find out if you have a case and how much you could potentially get.
Thanks, Vernon. You heard it, folks. If you've been injured, call and find out how much you qualify for. Call 800-745-9090. That's 800-745-9090. 800-745-9090. Advertisement sponsored by Legal Help Center. May not be available in all states.
And we are back in the Legal Lounge. Once again, thank you so much for joining us. We're streaming live right now on Facebook, monitoring the comments if you want to jump in there. Facebook.com/CRN Talk. And also, as always, all previous and past sessions are available on Facebook. On Richard's Facebook, you can find him, Richard A. Nixon. Also on CRN's Facebook, Facebook.com/CRN Talk. Also on Rumble and also on YouTube. And of course, it's a podcast on CRNTalk.com/podcaster. Richard, you were talking about Texas v. Johnson.
Yes. And before I was very politely interrupted, Mike.
Yeah, beg your pardon.
At one point, a demonstrator handed Johnson an American flag that was stolen from a flagpole outside one of the targeted buildings. Now, this is what happened. The court said, the U.S. Supreme Court, 1989, recognizing that the right to differ is the centerpiece of our First Amendment freedoms, a government cannot mandate by fiat a feeling of unity in its citizens. Therefore, that very same government cannot carve out a symbol of unity and prescribe a set of approved messages to be associated with that symbol. I want to say, why not? But anyway, the court also concluded that the flag burning in this case did not cause or threaten to cause a breach of the peace. And so I wondered, did it really turn on that very slim little issue there? Had they had a witness that said, well, it looks like a couple guys are going to duke it out there because you're burning the flag, would the court have said just the opposite? Oh, okay, then you cannot desecrate, you cannot burn it, it's against the law. And at that time, Mike, as we talked about in our show prep, 48 states plus the District of Columbia had said that it was a violation and you could be penalized and fined for burning the flag. And of course, we have to remember, we're talking about desecration, and the importance of that is this, that it's an improper burning of the flag, because I understand that there are approved methods by which one can dispose of a flag that say it's all ripped or beyond.
Yeah, if you're going to retire, we did that in junior high, Richard. One time we had an old flag at our junior high that was in service since literally Pearl Harbor Day, interestingly enough.
Wow.
And according to the Kiwanis Club and the Legionnaires and the VFW who were at this ceremony, the proper way to dispose of a flag or retire a flag is to burn it. And that's what we did. But Mr. Johnson, he was making a political statement.
Yes.
And Texas v. Johnson, the Supreme Court, as you said, 1989, the Supreme Court said that was political speech covered by the First Amendment.
Yes. Now, of course, anybody that reads the First Amendment knows that it's not, the First Amendment doesn't protect conduct. It only protects speech. This was conduct. Burning a flag was conduct. Now, it was in part a part of his, if you will, overall conduct speech, if you will, by saying he F the draft and all this other jazz that he was saying. But anyway, the point is that we did have some dissents here, and I'm going to read just a part of Justice John Paul Stevens, who turns out was not my favorite. Yeah. However, he did say, very fine words, the flag is more than a proud symbol of the courage, determination, and the gifts of nature that transformed 13 fledgling colonies into a world power. It is a symbol of freedom, of equal opportunity, of religious tolerance, and of goodwill for other people who share our aspirations. The value of the flag as a symbol cannot be measured. The case has nothing to do with disagreeable ideas. It involves disagreeable conduct, in my opinion, and therefore, because it's conduct, it should not be covered under the First Amendment. And people who did it, in this case, Mr. Johnson, should be punished according to the law.
Reading this executive order, of course, this is the President Trump's EO, which came out August 25th, 2025, title which is prosecuting burning of the American flag. The language that I said there, Richard, in this EO, that the court has never held that the American flag desecration conducted in a manner that is likely to incite imminent lawless action. Likely to incite imminent lawless action comes from an incitement case, Brandenburg versus Ohio, 1969. And so when I read between the lines here, Richard, is that Mr. Trump and his administration are conceding the fact that Texas v. Johnson, in terms of just burning the flag as speech, is permissible. But if you're in an instance where by burning that flag, perhaps in public, perhaps in a heated protest, and that becomes the protest to become even more violent, then that is what you can be prosecuted for. That's what I'm reading. Correct me if I'm wrong.
Okay. No, you might very well be right, Mike. But my question comes up. As we had talked in our show prep today, you were concerned, we were referring to actually President Bush at the time of the president becoming all too powerful. And this is why I was concerned here, and maybe don't have my thinking cap on, as my teacher used to say, but what is President Trump's authority for making this, quote, law? This is an EO. Remember, an EO must always attach to some law that Congress has written, because under Article 1, as we said, only Congress can write a law. So Mr. Trump, if he's going to enforce the law, if you will, who wrote the law? What is the law? And I don't know what it is at this point. But however, let me back up just for a second here. Let's talk about Mr. Biden. We don't see that man anymore.
Yeah, I wonder where he is.
Very quickly. Once upon a time, much like President Trump today, Joe Biden was outspoken about protecting Old Glory from desecration, calling the flag a symbol that is needed to unite this nation. In fact, he was so incensed about the 1989 Supreme Court decision protecting flag burning as free speech that he crafted legislation to circumvent the High Court's decision. A version of his bill became law. That law, which involved a $1,000 fine or a year in prison for flag desecrators, was ultimately struck down by the court as a violation of the First Amendment. At the time, Biden said he would, if necessary, support a constitutional amendment to make flag burning illegal. That time arrived the next year. Though 16 Democrats voted for a constitutional amendment banning desecration of the flag, Joe Biden was not among them. His campaign spokesman, Andrew Bates, told the Washington Post in July that Biden now does not support a constitutional amendment banning flag burning. Joe Biden's tall tales about where he stands on pivotal issues rarely stands up to scrutiny, and that's the end of that.
So he flip-flopped.
Yeah.
He said one thing, he did another. I mean, that's kind of Joe Biden's right in his wheelhouse. But this EO, Richard, okay, my personal opinion. This is symbolic. I mean, like you said, there's nothing in this EO that's found or fact in law.
Well, okay, maybe.
Well, I take that back, Richard, because actually those 48 states, and plus the District of Columbia that had laws on the books banning flag burning, some of those laws are still on the books. Ah. So can Mr. Trump come in? But those are state laws. Those aren't federal laws.
That's true, and they're probably illegal now. I mean, they're not enforceable, I guess is what I'm saying. No, what else is interesting, what if we trace it to our Pledge of Allegiance? Now, that's not, quote, a law, but it's certainly something that dictates certain behavior in this country. I pledge allegiance to the flag and to the republic for which it stands. Now, that not only tells us this is not a democracy, it's a republic, and also we are pledging allegiance to the flag. I would say violating that pledge should be, if it isn't, a felony.
Okay.
And therefore, based upon the fact that there is a felony, I say Mr. Trump's got the kudos and the balls to keep going.
Well, perhaps this is a message to some of those red states out there that still have that flag burning desecration laws on the books, that if they do prosecute and it goes to the Supreme Court, maybe that this Supreme Court, rather than the Warren Court back then, it'll be a little bit different. Stick around, Rich. We'll be right back. Stay with us.
What are the most important issues facing people in California? Inflation and crime. Hi, Aaron here. We at California Deluxe Windows addressed both. We are making beautiful energy-efficient custom-fit windows right here in LA, saving on waiting time and the cost, so it beats inflation. And our security features are unlike anybody else. Steel-reinforced frames, metal comlocks, night latches made from Lexan, almost unbreakable, like a football helmet, interlock, and more. This is our deflation security cell with 30% discount on top of it. And our installation is so precise, we do not break your stucco. Your house can be covered with potato chips and we wouldn't crack one. Call us 866-988-5100. 866-988-5100. 866-988-5100.
CSLB 774518. Some restrictions apply. Savor the past and savor the glory days of Las Vegas. Enjoy 70 years of true Las Vegas history as 4 generations of family wait to greet you at the legendary Bootlegger Italian Bistro. Wine, dine, and experience Mama Maria's award-winning original recipes while surrounded by original family photos and celebrity memorabilia. Enjoy piano artistry nightly with music from the Great American Songbook in our main formal dining room. The Bootlegger Italian Bistro, 7700 Las Vegas Boulevard South. In the entertainment capital of the world, the Bootlegger Italian Bistro, open 7 days a week. 7700 Las Vegas Boulevard South, in the entertainment capital of the world. It's Vegas, baby.
Are you ready to make a difference for the environment while helping the visually impaired at the same time? Then donate your vehicle to Heritage for the Blind today by calling 800-785-9618. Every donated vehicle will either be properly recycled in an eco-friendly manner or given a new life through reuse. Donating your vehicle is easy. Simply call 1-800-785-9618 and Heritage for the Blind will do the rest. They'll even arrange for your vehicle to be picked up at no cost to you. And for a limited time, when you donate your car, you'll receive a $200 restaurant voucher and a 2-night, 3-day hotel stay at one of 50 locations. Call 800-785-9618 right now to schedule your tax-deductible vehicle donation and make a positive impact on the environment while helping others. Heritage for the Blind, where every car donation counts and every person makes a difference. Call 1-800-785-9618 now.
And we are back in the Legal Lounge. Quick Department of Corrections. In that last segment, I said that Texas v. Johnson was under the Warren Court. That was incorrect. It's under the Rehnquist Court. Brandenburg was under the Warren Court. So
yes, that's correct.
I apologize for the error. All right, Richard, let's talk a little bit more executive orders. Let's talk about something we've covered extensively on this show. Let's talk about birthright citizenship.
Yes, we sure did.
So the birthright system, this is one of the very first executive orders that President Trump signed. He signed this on January 20th, 2025, literally the day he took office. By authority vested in me as president by the Constitution and the laws of the United States of America. The privilege of United States citizenship is a priceless and profound gift. The 14th Amendment states all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state within where they reside. Mr. Trump, the 14th Amendment has also always excluded from birthright citizenship persons who are born in the United States but not subject to the jurisdiction thereof. Consistent with this understanding, the Congress has further specified through legislation that a person born in the United States and subject to the jurisdiction thereof is a national and citizen of the United States at birth, 8 U.S.C. 1401, generally mirroring the 14th Amendment text. Among the categories of individuals born in the United States and not subject to the jurisdiction thereof, the privileges of the United States citizenship does not automatically extend to persons born in the United States. Richard, you didn't think this went far enough, correct?
Well, yes. Now, there's several things I'd like to say about this. Of course, people know I am a pro-Trump person. However, it hurts me to have to criticize my president, probably the greatest president in my lifetime. However, being true to my character, I must cite some things from the Constitution. Mr. Trump is not an attorney. He was advised, I would think, to word his EO as it's worded. So let me just remind everyone out there of this. Article 1 of the U.S. Constitution says the following, Section 1, all, underline the word all, legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives. Now we go to Article 2, which deals with the president's powers. And among those powers, we have the following. He, meaning the president, shall, this is Article 2, Section 3, he shall take care that the laws be faithfully executed. So, presumably, this EO is enforcing an existing law. Now, we do have, quote, law on the books in this particular area of birthright citizenship. Most of them are case law. The first one before the cases starts in 1868, where the author of the Citizenship Clause, Senator Howard, simply said that what he meant when he wrote it, because he was the author, is that persons born in the United States who are of foreigners, aliens, ambassadors, or foreign ministers are not birthright citizens. Again, I'm not going to repeat all this, but in 1872, in the Slaughterhouse case, we have a similar understanding. It was intended, that is to say, and subject to the jurisdiction thereof, was intended to exclude from its operation children of ministers, consuls, and so on, and subjects of foreign states. We also have the Elk versus Wilkins case, 1884, which again repeats the fact that it was meant for persons that were born here, were not really subjects of the Citizen Clause. So the point is, under the Elk versus Wilkins case, it takes more than just being subject to their political jurisdiction. They must owe them direct and immediate allegiance. So the whole point is this, that if the children that are born here if their parents do not owe allegiance to this country, that is because they're foreigners or aliens or whatever other position, that child is not a citizen based on birth. And to conclude, we have another case called Wong Kim Ark for instances we will not go into great detail, but in any event, both parents were permanent legal residents. They had a child here. The court, I think, in error found that the child was a citizen based on birth. However, that is the law, 1898. So my point is this, Mr. Trump could have chosen from any of these cases the proper wording for him to, if you will, write an EO that would have been constitutional.
Well, this is the wording that he used, and we're going to flush more of this out after this next break. It is the policy of the United States that no department or agency of the United States government shall issue documents recognizing United States citizenship or accept documents issued by state, local, or other governments or authorities purporting to recognize United States citizenship to a person who, one, when the person's mother was unlawfully present in the United States and the person's father was not a United States citizen or lawful permanent resident at the time of said person's birth, or two, when the person's mother's presence in the United States was lawful but temporary and the person's father was not a United States citizen or lawful permanent resident at the time of said person's birth. We're going to flush more of this after the break. Stay with us.
From basement podcasts
is this thing on?
to social media.
I'm so funny.
These days, it seems like just about anyone can share their 2 cents. But with so many voices out there, who can you trust? Well, how about LA's first and longest running talk station? For over 60 years, AM 790 KABC has been the trusted source of news and information for Southern Californians from San Diego to Santa Barbara and beyond. With powerhouse hosts like John Phillips, Randy Wang, Armstrong and Getty, Frank Motek, Guy Benson, and Vince Colonnese, you can rest assured you'll receive the news of the day with honesty, insight, truth, and above all, facts. On air on AM 790, online at KABC.com, and on the go with the free KABC app for news talk you can depend on. Trust us. Fast-paced, fact-based, AM 790 KABC.
1 out of 2 Americans thinks their life is worthy of a book. Here's another startling stat. You may be one of the 15% of people who bothered to start your book and one of the 6% that got halfway through it, but your gem of an idea likely died. Or did it? Some published authors are making significant money, so join the ranks of the successful people that finished their books with help from Dorrance Publishing. Call right now and our experienced editors and writers will explain to you what it's going to take to get your book completely written, published, and then taken to market to sell it. It's a free consultation, so call right now. Find out how much time and money it takes to finally get that book idea of yours published. Make your dreams happen. Call Dorrance Publishing right now.
800-786-1468. 800-786-1468. 800-786-1468. That's 800-786-1468.
Are you annoyed, angry, or maybe there's another word you want to use about where your tax dollars are going? Let's face it, the government does a terrible job of managing money, especially when it's yours and mine. Tax dollars are being wasted, and all the government does is have their hand out for more. So what do? They send you, the tax-paying American or business owner, a letter saying you underpaid your taxes, and you owe us a lot more. Don't laugh and don't cry. Call the Tax Resources Network now. Their trained experts can help negotiate between you and the IRS and take all the stress off your back. And if you're lucky, save you a boatload of tax money. So before you think about calling the IRS, if you owe $10,000 or more in back taxes, or you haven't filed in a while, call us right now.
888-816-7701. 888-816-7701. 888-816-7701. That's 888-816-7701.
It's time to rediscover Ka'anapali Resort on Maui. Goodbye stress and work. Hello paradise and fun. Restaurants, hotels, golf, spas, hiking, shopping, activities of all kinds, or just lounging on the beach and listening to the waves. Visit Ka'anapaliResort.com, KAANAPALI Resort.com. Ka'anapali Resort on the west side of Maui.
Hi everyone, this is Ron Say. I played baseball for the Los Angeles Dodgers, Chicago Cubs, and Oakland A's. My Dodger teams won 4 National League pennants and a World Series. Now I am tackling a new challenge. I am hosting a new sports show called We'll See About That. We will look at the aspects of sports, baseball, football, basketball, hockey, soccer, and much more. Plus, you will be able to get my honest opinions on the big stories of the day. Join me for We'll See About That, Saturdays at 11 a.m. Pacific Time right here on crntalk.com.
We are back in the Legal Lounge, CRN Digital Talk Radio, crntalk.com. One of the buttons on my console is starting to stick. So, Richard, I read the language from the Birthright Citizenship EO, but I read it quite fast. And so I wanted to read this section to the policy portion of this EO a little bit more to flush this out and understand why you don't think it went far enough. It is the policy of the United States that let's skip that part. When the person's mother was unlawfully present, illegal, in the United States, and the person's father was not a United States citizen or lawful permanent resident at the time of said person's birth, or 2, when the person's mother's presence in the United States was lawful but temporary, and the person's father was not a United States citizen or lawful permanent resident at the time of said person's birth, no birthright citizenship.
Okay. My problem is this, Mike.
Okay.
Can we or can anyone point to the law that Mr. Trump is referring to when he wrote his EO? Remember, an EO must be attached to some law. He's enforcing a law that Congress passed. Mm-hmm. Under Article 1, only Congress can make law. Okay, now here's the existing law, very quickly again, that the author of the Citizenship Clause, interpreting and subject to the jurisdiction thereof portion of the 14th Amendment, Section 1, said that he intended to exclude people or persons born in the United States who are of foreigners, aliens, and ambassadors. What that meant was this: all people born here were citizens except for the following, I'm going to repeat it, except for persons born in the United States whose parents were foreigners or aliens, to shorten it. So if your parents were foreigners or aliens, and I don't mean this in a pejorative sense, they simply were not American citizens or permanent legal residents, if that be the case, then your being born here does not confer citizenship upon you. Now, very quickly, we have an 1872 case, Slaughterhouse. It says basically the same thing. I'm not going to repeat it. We then have 1884 Elk versus Wilkins, basically saying the same thing, except it went into a little more detail and said that your allegiance and loyalty to this country must be complete and absolute. If it's not, then the child being born here is not a citizen. Now, here's my problem. Excuse me. I don't see, or I should see, I should say that all Mr. Trump had to do was adopt the language from any of these cases. I would suggest Elk versus Wilkins, and simply use that as the basis for his EO, properly worded. Instead, what he did is he actually made it possible for someone who is here illegally, namely a mother, and again, I don't mean that in the pejorative sense, but she's here, she's not a citizen, and it gave the opportunity for someone of that ilk to have a child here that is eventually declared a citizen. I think that's wrong.
Because the father or mother in this case, so in your hypo, the mother is an illegal. The father is a naturalized United States citizen. If they have a child, that citizen automatically birthright citizenship confers.
That's right. And I don't understand why he would depart from the existing law. The existing law insisted that if either one of the parents were illegal or foreign, the child could not be a citizen. What he's done is he's opened up a leeway for at least illegal women, if you will, either illegal or temporarily here, to give birth to children who are otherwise would not be citizens under the existing law. They are now going to be determined to be citizens based on Mr. Trump's EO.
Well, let's talk about some of the the legislation we've seen. Going back all the way to 1798, I believe that there was legislation where in order for birthright citizenship to be, or citizenship in general to be conferred, you must be 5 years in residence and of good standing and showing allegiance to the United States.
Absolutely.
But then, fast forward 200 years later, and this is something that you wrote about extensively in your fantastic book, American Illusion of Freedom, which is available on Amazon.com, Barnes & Noble, and on iTunes. H.R. 1868.
Now you're getting hot.
Now, this is a piece of legislation that was introduced into the House of Representatives by Mr. Deal of Georgia.
Yes.
What's the story with this piece of legislation?
Well, what's interesting about it is this, and of course it happens to be on page 167 of my world-famous book.
American Illusion of Freedom, available where Amazon, 5 books are sold.
And it's called H.R. 1868. Interestingly, 1868 is the year. Birthright Citizenship Act of 2009, and what happened to it is it didn't pass muster. It was never made the law. This was simply a proposition.
It got parked in committee and never really came out of committee.
That's it. However, this is what it said basically, that the citizenship at birth, for those purposes, if a person is born in the United States of certain parents, one of whom is, and we're going to give you a choice of 3 things. If one of your parents was a U.S. citizen or national, right there, that's saying the other one can be illegal. He could be an MS-13 gang member. That's okay. Your baby's still going to be a citizen. Number 2, a lawful permanent resident alien whose residence is in the United States. So he's lawfully here, just like in the Wong Kim Ark case. 3, an alien performing active service in the U.S. Armed Forces. That might be okay, too. But my point is, Mr. Trump is fashioning his EO after the Birthright Citizenship Act of 2009, which has already been shot down by Congress. So I don't know why he doesn't just withdraw his existing EO, resubmit it, and reword Elk versus Wilkins 1884, and that way, if you were not a citizen or a permanent legal resident, if your child was born here, that child would not be a citizen.
Well, Richard, I mean, we got about a minute left, but if he did put his EO, based it off Wong Kim Ark,
yes,
Wong Kim Ark would have to be redecided, because Wong Kim Ark didn't really go our way when it comes to birthright citizenship.
No,
right?
But if we take Wong Kim Ark, we ignore the fact that they owed allegiance to China. Yeah. What I'm simply saying is, if both parties are either permanent legal residents or here as citizens, that is the only situation under which
birthright
their child being born here would be, yes.
That makes sense to me.
And again, who could argue with that? In other words, the Supreme Court would be arguing with their own Supreme Court case. So I don't understand. I'm trying to appreciate why the president felt that he had to allow someone who's clearly, he's such a pro-American person. He just passed another EO regarding flag burning.
Yeah.
Who's more concerned with this country than he is?
Not a lot. Richard, we're going to
get
talk. There's you mentioned subject to the jurisdiction thereof. We're going to talk about an interesting case regarding that language, Moncada versus Rubio, just cited on the Ninth Circuit right after the break.
Absolutely.
This is baseball's Ron Say. Nowadays, it seems like nothing is built to last. Phones, appliances, cars, computers, but the new Michelin Defender 2 tire is designed to outlast. With a quiet and comfortable ride, you will have the confidence you need on the roads, whether they're wet or dry. So goodbye to the short-lived and hello to something that lasts. Get your set of Michelin Defender 2 tires at Hank's Tires, 19951 Ventura Boulevard in Woodland Hills. Call my buddy Steve Goldberg at 818-340-4200. That's 818-340-4200. Hank's Tires is also built to last. Hank opened Hank's Tires in 1953, and we are the oldest tire and auto repair shop in the San Fernando Valley with 100% customer satisfaction. Hank's is AAA approved for all of your auto repair needs. Call Hank's Tires at 818-340-4200 and tell them Ron Say sent you.
You order a glass of your favorite Cabernet, fresh asparagus, hollandaise on the side, a filet, medium rare. You unfurl your napkin with a flair, close your eyes, and prepare to listen. Ah, there it is. The sweet music you long to hear. The sizzle. The sizzle of a Ruth's Chris steak.
The most magnificent corn-fed prime beef, broiled to perfection at 1,800 degrees. Some call it a sizzle. We call it an anthem.
As the waiter approaches, you think, is this one mine or that one?
Ruth's Chris Steakhouse. Like Ruth always said, life's too short to eat anywhere else.
Make a reservation online at ruthschris.com or by calling 800-544-0808.
We are back in the Legal Lounge, CRN Digital Talk Radio, CRNTalk.com. Richard mentioned his fantastic book, America: An Illusion of Freedom. It's available on Amazon.com, Barnes & Noble, and on iTunes. 4th edition coming soon. Is the 4th edition out yet, Richard?
Absolutely.
You got that worked out?
Burning hot, too.
Oh, right. Hot off the presses, folks.
Absolutely.
Make sure to check out the 4th edition. A lot of current, more recent cases. The Brune case.
Absolutely.
Very important we talked about. Dobbs, of course. We talked previously in the show about several historical cases regarding birthright citizenship, but we have something quite current right out of the Ninth Circuit here, and this is Moncada versus Rubio. This one's interesting, Richard.
Yes, and I'll just introduce it, Mike, and then we'll get into it. This is appearing in the Daily Journal, August 21st of this year. And basically the caption is, a man was born and living in the United States for over 70 years, was not a birthright citizen because of his father's apparently diplomatic immunity at the time of his birth. Now, what happened here is this. Roberto Moncada was born in New York City in July of 1950. His father was a Nicaraguan national, worked for Nicaragua's permanent mission to the United Nations. And for nearly 70 years, Moncada lived and worked in the United States as an American citizen. In fact, he applied for his
passport 5 times, right?
5 different times. It was granted 5 different times, which is proof that the person is a citizen. However, it was because that previous to this, the assumption was, or at least the proof was, that the father of Mr. Moncada, Roberto, was a consul, and a consul does not enjoy diplomatic immunity. However, it was now recently determined that his father, that is Roberto's father, was in fact an attaché. An attaché does enjoy diplomatic immunity, which feathers down to his children, which would include our current man here, Roberto. And what does that mean? That means if we read the 14th Amendment, again, Citizenship Clause, all persons, any person born or naturalized and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. However, that means that you have to be subject to the jurisdiction. If, in fact, his father was an attaché and was immune from being liable, subject to the jurisdiction, that meant that he was not a citizen. Because remember, again, the 14th Amendment, Section 1 basically says, in order to be a citizen, you must be born here and subject to the jurisdiction. Because this attaché was immune from that, he was not a citizen.
So what's Mr. Moncada to do?
All he can do is go to the Supreme Court. Now, again, this is...
He's not subject to deportation over this, is he?
I don't know. This is the Ninth Circuit. Now, I don't know what they'll do. Obviously, he's here... he was here properly.
Yeah, he seems to be in good standing. He never had trouble with the law or anything like that.
Well, and he's from Nicaragua, of all places. Who knows? I don't know, Mike. I knew you remind me of somebody else that whenever I tell them something, they always ask me a question, and I don't know the answer. So, I don't know.
This speaks to something that I think is an important, which you brought up in our prep session, Richard, which I think is super important, and I think that a lot of people haven't really flushed out, and you have done so excellently well. This has to do with territorial versus political jurisdiction when it comes to the subject of jurisdiction thereof.
Exactly.
Please flesh that out for us.
Yes. Well, okay. If you read the citizenship clause, basically says that all persons born or naturalized and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. If you look at that particular section that says, and subject to the jurisdiction thereof, if you read that, and I think improperly, like the left does, and let me give you a fast hypo. If I were to go to Japan tomorrow, I would be subject to their rules. I would have to obey their traffic signs and...
Yeah, you can't knock over a sushi spot or anything like that. Yeah.
So that is how the left likes to interpret this. However, for other reasons, too much to talk about today, having to do with proper construction of canons of construction on how to interpret a statute, that is improper. However, this is the Ninth Circuit. So impropriety, I think, is inborn or inbred into the Ninth Circuit. In any event, what they're saying is if you interpret it that way, then in order to be a citizen born here, you must be subject to these certain rules. And yet, intersecting that is we have some rules regarding who is immune and who isn't when it comes to people of governments other than our own. And in this particular situation, Mr. Roberto's father happened to be an attaché. An attaché is immune from those rules.
Yeah.
Had he been, as was currently originally thought, a consul, he would not have been immune, and this Roberto would be a citizen.
Territorial meaning, like you said, the hypo being that, you're in someone's country, you got, subject to their laws.
I see what you mean.
Political is more about subject to custom and also to the allegiance of that particular country.
Right. You've got the two jurisdictions going in opposite directions. If it's a territorial jurisdiction, that means that the government is imposing certain rules upon you. The proper interpretation, as all the case law shows, is what it means is the party is showing allegiance or loyalty to its government. So in either case, is one acting and the other acting.
One's reactive, one's proactive.
Exactly.
Stick around, you guys. Wrap things up right after the break. Stick with us.
You're experiencing pain, back pain, shoulder, elbow, or hand pain, pain from a sports injury. If so, schedule a visit with Dr. Michael Sheps, the leading expert in laser therapy for pain management. Call 310-873-4422 or go to drsheps.com. Experience Epic T, the breakthrough laser therapy system that Dr. Sheps developed to make you pain-free in less time. Laser therapy is a non-invasive, safe, and effective in-office procedure that penetrates deep into your skin without damaging the tissue. It perfectly targets areas of pain to promote fast, natural healing. Relax your muscles, ease muscle spasms, joint stiffness, and arthritis pain while increasing blood circulation. For over 25 years, Dr. Sheps has helped Olympic athletes and sports enthusiasts alike get back in the game. Schedule your visit with Dr. Sheps at his Brentwood office in California. Call 310-873-4422 or visit drsheps.com. That's DRSHEPS.com. 310-873-4422. The Kahanapali Beach Resort on Maui is open, and we are welcoming guests. All properties are taking reservations now. Come visit. Go to kahanapaliresort.com. Experience Kahanapali Beach Resort on the tropical west side of Maui, just a short drive from the airport. All highways are open, a collection of relaxing resort properties, our award-winning beach, delectable dining, world-class restaurants, and activities for everyone. Snorkeling, surfing, sailboating, water sports of all kinds, beach and ocean dining, stargazing, beautiful sunsets every night, golf, sun, fun, food, wine, and all in paradise. Visit Kahanapali Beach Resort on Maui. Relax. Reservations are now available. Start with a visit to kahanapaliresort.com. That's KAANAPALI resort.com. The Kahanapali Beach Resort is waiting for you.
Attention, those of you looking to go on a fun vacation and see the world on the cheap. Today, the U.S. dollar is worth even more in other countries, so there's never been a better time to travel outside the USA. The dollar is worth over $1.30 in Canadian dollars, and it's the same for Australia. You can fly there today and have fun and maximize your travel dollar. Your U.S. dollar is worth over $3 in Brazilian reals, and it's worth over $18 in Mexican pesos. Plus, in Argentina, it's worth over $27 in Argentine pesos. Just think of the bargains you'll get. And the way you get the cheapest airfare to any destination is by calling Tickets That Cheap. Save up to 75% on your foreign vacation tickets. Don't wait. Call now.
802-317-1979. 802-317-1979. 802-317-1979. That's 802-317-1979.
We are back in the Legal Lounge. Thank you so much for spending some time with us. America and Illusion of Freedom is Richard's fantastic book, 4th edition, hot off the presses, available on Amazon.com, Barnes & Noble, and on iTunes. And Richard, we talked before about this a couple times. The OJ case. OJ, of course, I thought he pretty much did it. He was acquitted of murder, double murder, acquitted, walked free, but then the Goldman family sued him, and he had a huge judgment awarded against him. And there's a fantastic article here in the Daily Journal, Parallel Proceedings, Conflicting Rules, Managing Civil and Criminal Exposure.
Yes.
It kind of talks the difference between civil and criminal adjudication.
Yes. Well, as the article begins, when a civil case and a criminal case arise from the same act, that's the important thing, the same act, omission, or set of circumstances, they are referred to as parallel proceedings. The two types of cases have distinct natures. First, criminal cases are brought and prosecuted by the state or federal government. In California, criminal actions are brought in the name of the people of the state of California. And in civil cases, the action is prosecuted by the aggrieved party, that is the plaintiff, against the alleged wrongdoer, that is the defendant. And there are different levels of proof required in order for the state, if you will, to win a criminal action, as opposed to the plaintiff to win a civil action.
It's generally the burden of proof is higher in a criminal case than in a civil
Absolutely.
case. Okay. What else we got here?
Now, in a civil defendant is only liable if he pleads guilty or is found guilty by preponderance of the evidence, meaning that he is more likely than not, that is greater than 50%, guilty, etc. Now they're using the term guilty, but it's really not properly used in a civil action. It's simply, the word is liable. Now, in civil cases, as what they call res judicata or collateral estoppel, you've got an issue as to whether or not one of the cases goes before the other. And we were mentioning the boxer Tyson.
Yeah, Mike Tyson.
Who got into something with a young woman in his apartment, and she sued him both criminally. The state prosecuted him.
Yeah.
He was found guilty or he pled guilty. And then, just very smartly, his girlfriend, if you will, ex-girlfriend, sued him for civil damages because he took advantage of her and so on. And so, based upon the fact that they already had a slam dunk, they proved beyond a reasonable doubt, let's say 90%. All they had to prove was 50% when they go to the civil action, and that was pretty much done. And much of what had to be proven was already proven, and you can simply bring it over from the criminal action, bring it over to the civil action, ask the court for permission to accept that as judicial notice, and bingo, he's now found liable for X number, and I think in this case a couple million.
Yeah, a couple $1 million. Yeah, yes. I know that you can avail yourself of your Fifth Amendment rights in a criminal trial. Can you do it in a civil trial?
Well, that's the interesting thing now. If you take the Fifth Amendment during your civil trial, assuming it's first before the criminal, then, of course, they can draw inferences in the civil action against your taking the Fifth. And they can go against you for that.
In the civil trial.
In the civil trial. Now, again, that might help you in the criminal trial because you took the Fifth. However, like I said, you're running the risk that they are going to comment on it, and they're going to say he's probably guilty. That's why he took the Fifth.
We're almost out of time. So being parallel track, civil and criminal, not a double jeopardy issue.
That is correct. That's because, as you cited very brilliantly, Mike.
Oh, thank you.
In the criminal action, it's the state that's going after the defendant. In the civil action, it's a particular individual.
Two different parties involved.
Exactly.
So not the same party against the same party, which would be a Fifth Amendment issue. Richard, this is a fun one. We're out of time. Thank you very much.
It's wonderful. Thank you very much.
And we'll see you guys next week here in the Legal Lounge. Make sure to check out Richard's fantastic book, 4th edition, America: An Illusion of Freedom, available on Amazon.com, Barnes & Noble, and on iTunes. As always, check us out on our archives, on Rumble, and on YouTube. We'll see you guys here next week in the Legal Lounge.